Okay, please help me shut the door. Okay. Welcome, sir, and welcome to a legal perspective on the political happenings in Edo State. This is part of a digital conversation series, and it's by Business Day's Legal Business Unit. And we're also in collaboration with the Edo Political Forum. Joining me in the studio today is this Zoom webinar today is Mr. Osaro Eghobamien, who is a senior advocate of Nigeria. Welcome, and thank you for joining us today, sir. Yeah.
Thank you for having me. Thank you very much indeed. I consider it a privilege. Thank you.
Our pleasure, sir. Well, as suggested in the title of this event, the distinguished guest will provide a legal analysis on some of the recent events surrounding the Edo State election. And this will take the form of an interview. If you have any questions, please post them in our Q&A section, and he will address them at the end. So let me begin with the separation of powers. I'll first, give a brief definition. Separation of powers refers to the division of government responsibilities into distinct branches to limit any one branch from performing the core functions of the other. Do you think that there's anything going on in Edo State that could be interpreted as a breach in the doctrine of the separation of powers? Is the executive encroaching too much into the affairs of the legislature?
Again, thank you for having me, and let me welcome everyone who is joining us from the ancient city of the Benin Empire, a city of culture and tradition. We're very proud of where we're speaking from. Thank you very much. Your question is, are there any reasons to believe that the executive is there's an incursion into affairs of the legislature? Yeah. I'm going to answer it by the issues that are on ground. So I will contextualize what you say against what has happened recently. Of course, generally there is separation of powers. There's no question about that. But you have to understand how this works. The executive would normally proclaim, in other words, it will pronounce the beginning of the house of a legislature. What that simply means is that there's an official announcement that it is now time for the house to be inaugurated. That is done by the executive. What looks ostensibly appears to be an incursion is the fact that when the governor made that pronouncement and the clerk then invited members of the house to be inaugurated, only 7 showed up. So there's been litigation that has ensued where the governor is embroiled in that litigation. And that's why it looks as if there is an interference. And let me explain the background to that. When 7 actually appeared, it meant that 15, normally 24, 15 were absent. There's a precondition by which you must satisfy before you are inaugurated. That condition is you must take an oath. So the assumption is that only 7 took the oath of allegiance and appeared. Now, that 15 contested that process on the grounds that they did not obtain notices. That matter is still pending in courts. So talking about the court process, and since we're lawyers, the failure to decide certain matters urgently also leads to further degeneration. So that matter is still in courts, okay, as to whether or not those 15 got notices. Now, where did the governor get involved? Whilst that matter was pending, the elect members who had not been inaugurated took out a petition to the National Assembly to look into the matter. The National Assembly then looked into the matter and came to the conclusion that with only 7 members in the House, there had been created a situation where it was inconvenient. I think that's not the right word. It was, there had been a prevailing circumstance where the House could not pass laws. So the National Assembly then decided to step into the shoes of the State Assembly. In other words, it will create laws in circumstances where it considered that the State Assembly could not make laws for the peace, good governance of the states. The governor got involved because it was the governor who proclaimed, who made the announcement. And so there's another litigation that the governor's announcement or pronouncement was erroneous. Okay?
Yes.
So there were 2 issues that the court pronounced upon. The court pronounced, firstly, that the National Assembly could not, under those circumstances, in other words, the criteria for the National Assembly to take over the functions of the State Assembly had not been met or satisfied. It said there were no prevailing circumstances in the state that would cause the National Assembly to take over the affairs of the states. It also made the court also made another pronouncement, made 2 pronouncements. One was that the National Assembly was wrong to do what they did, but also that the state governor had made his official declaration to start the House, and he was not required to make another one. What that meant was that there was legitimacy to the conduct of what 7 members did in the House. So I think that's where we start from. So when you say that separation of powers, it is true you have separation of power, but I thought it was necessary to lay a background as to how the governor started getting involved. Of course, the governor cannot pass laws, but he proclaims, he expressly, publicly pronounces the commencement of the State Assembly.
Okay.
Let me stop there for one moment.
Right. Well, let's digest that. But just to follow up with that, those insightful comments, you said that seven members sat down and this resolution was passed, or as an inauguration. What about the quorum? What the legal term called a quorum? And also, even beyond the legality, there's a school of thought, and a lot of people are coming out and saying that the majority interest should prevail, and they're citing the quorum being present as that legal backing for that principle. What are your thoughts on this?
So let's clarify your question so that the answers will be apportioned accordingly. The proclamation is simply a public announcement. That's what the governor did. The governor, by the Constitution, is required to make a public announcement that the House should now commence its business after every election, okay? And that's where his function ceases in the interrelationship between the executive and the legislature. Your further question is that if you had 7 in the House, could that 7 legitimately conduct the House of the business? And then the third question is, could it form a quorum to pass resolutions where you needed 2/3 to pass resolutions? So let me answer your questions accordingly. The first one is that the governor did make a pronouncement. At the time he made the pronouncement, the clerk then invites the members-elect to inaugurate them into the House. It is contended that only 7 presented themselves, and the other 15 did not. So that matter is sub judice. The other 15 say that we did not get notice. So that's one issue. The second issue is, can 7 conduct the affairs of the House where you're expected to have 27 members? If only 7 presented themselves.
Senior advocate, it was, sorry, there seems to be a contradiction. Did you say 24? Is it 24 members or 27 members?
24. I said 24.
Okay, so just to clarify, yes, sir.
I said only 7 presented themselves. In other words, your question as to majority and all that, I'm trying to deal with that question.
Okay.
So 7 presented themselves. The other 15 is challenging it that we did not get notice. So that's in court. The third question is, and I would subdivide the third into 2 questions. First, can 7 conduct the affairs of the house? If only 7 presented themselves, I will contend, arguably, of course, that 7 can conduct the affairs of the house. But the further, more complicated question is, if you require to pass a resolution that requires 2/3 of 24, 2/3 of 24 gives us in rough, I think, about 9.
18.
Right?
Sorry.
Let's see, let's do that math very quickly. 3 and 24, you get 6, 18, correct.
Yes.
Absolutely correct. You're correct. That math was quicker than mine. Okay, you did 18 2/3 of 24. Now, so just 7 are seeming to pass laws. They don't even qualify. They don't satisfy that criteria. Now, bear in mind that there is a court pronouncement. That court pronouncement is significant. What it seems to be saying expressly and perhaps impliedly is that the proclamation was correct and that 7 who presented themselves should conduct the proceedings of the house. In that peculiar circumstance, perhaps 2/3 will not be 2/3 of 24, but 2/3 of 7, which is, it's an argument that commends itself to the extent that the court seems to be saying, look, I agree that the proclamation was okay. And once the proclamation was good, in other words, it had commended it had satisfied the criteria. And the second point is that the governor did not need to pass a second public pronouncement. What it means is that it's giving validity to the number, in my view, unless, of course, those other members presented themselves. So in giving validity to 7, and this is part of the argument, you have to understand that this is in court, so the arguments on both sides. In giving validity to 7, you will not be looking at 2/3 of 24 anymore. You will be looking at 2/3 of 7 or those who present themselves to be qualified. So that is the tricky point that we're faced with on the question of your 2/3 resolution, or 2/3 required to pass a resolution.
Okay, sir. Thank you very much for that insightful comment. What you mentioned earlier about the National Assembly's getting involved in state House of Assembly affairs. Now, as far as we know, that is the first time that that's happened in Nigeria. Do you think that, because you said that only special circumstances or emergency type scenarios that National Assembly can get involved, and some people are saying that this constitutes this series of affairs equates to that emergency. What are your thoughts on this, on people who say this?
Okay, so let's look at what are the words that are used in the Constitution. Then we begin to analyze it and see whether the National Assembly could possibly intervene in this case. At the time that the parties went to court, the basis upon which they went to court was that only 7 were conducting their affairs and 15 had been wrongly excluded. They've been excluded wrongly. That is their contention. What the Constitution says is that where the House, the State House of Assembly, is unable to make laws resulting from a prevailing circumstance in the states. So the word is prevailing circumstance, something of that nature, in the states, then the National Assembly could intervene. Now, it also has an exception which says as long as the State House, the State Assembly can continue to sit, that will not give rise to a situation that is a prevailing circumstance where the National Assembly could intervene. So when there's a crisis, The way I interpret that section is that the crisis is external to the State House of Assembly. That's an interpretation that commends itself because of the way the act is drafted. In other words, if there were to be a riotous situation where the House is unable to sit, or if there was a war situation in a state where the House cannot sit, or perhaps if there was an invasion where the failure is as a result of the internal regulations or breaches of the House, I don't think that is sufficient for the National Assembly to intervene. Now, whichever view you take, whatever view emerges from these debates, bear in mind that a court has pronounced on that issue. So whatever I say to you really doesn't matter. The court in Port Harcourt said the circumstances were insufficient for the National Assembly to intervene at that point. I guess the next question you perhaps want to ask is whether there's been further degeneration that could lead to the National Assembly intervening.
You read my mind, sir.
Right. Personally, and this is my personal view, I don't think so. And I think perhaps I should deal very briefly with the facts that jumped at you when I spoke, which was the recent event. And let me explain what had happened. When the governor defected to PDP, those 7 or 9 members, I mean, a few things happened. I think they are now 9 because some presented themselves subsequently to be inaugurated. Those 9 members also left to a different party, but one remained, I think was a deputy speaker. So those who were now in the House sought to impeach him, and they did impeach him. Now, the other members outside the House took a view that since they were in the majority, they could perhaps set up a parallel House. That's what I call it, because you can only do that within the premise of the House. So they allegedly went to a venue where they proceeded to conduct themselves as if they were in the State House of Assembly and sought to impeach officers who had taken a decision in the House. That led, of course, to a crisis because if you think about it clearly, that was a subversion of constitutional authority because the law says that you must do it within the House. Otherwise, you'll just have miscreants who will be purporting to run a parallel House, notwithstanding that they were members elect, they'd not been inaugurated into the House. So that led to a crisis. And when they held that, apparently they were moving to the State House to take over the place. Of course, the police intervened. But the police did not stop short of taking further action. So I understand that the Attorney General of Edo State has now has instituted an action seeking a specific order, what we refer to in law as a mandatory injunction, compelling the police to take action to what amounts to a treasonable felony. Of course, it's a state, you have treasonable felony against those members who sought to constitute a parallel House. Now, the question you then asked is, will that be considered to be subverting the situation in the House such that the National Assembly will intervene? I think my analysis answers itself. They couldn't possibly be considered as a constitutional parallel House, and therefore the National Assembly would have no circumstance and no reason to intervene in those situations.
Fantastic. Thank you very much, sir. I genuinely gained a lot of knowledge from this. I think this comes in very insightful, and you provided astute legal analysis. I'd like to thank you very much for your time. I think this should conclude the session. And you can find this interview on our Business Day YouTube page. And we have a catalog of these digital conversations. So thank you very much, sir.
Yeah, let me end by saying this. I think Business Day is doing this is good. And I think you can be educating a lot of people because there's a lot of misinformation and a symmetry of information out there. People really don't understand what is going on. So I commend Business Day. Thank you very much for having me.
Thank you very much, sir. The pleasure is ours.
Thank you.
Thank you.